Another thing that was a problem, and is still a problem for our state, was the proper funding of court-appointed special advocates that represent the interest of a child in a neglect suit or those type of things, rather than representing one of the parties that's accused or this or that. They represent just the child's interest, and there's always been a funding problem with that. We made steps towards addressing that. We also formed what is called the Early Intervention Planning Council, and what that does is that it finds children that are at risk, either because of neglect or juvenile delinquency, and steps in and provides services and counseling to those families. As you may or may not know, most children that end up in the juvenile delinquency system, unfortunately, were at one time the subject of neglect in their lives. It's very, very common. It happens most every time. Then we examined the number of children that we were holding in secure confinement at the Juvenile Detention Center. Did we really need to be holding 200 children a day? Was this approach something that served those children best and the people of our community best? And through some suggestions to me, I contacted and was able to lobby the Annie E. Casey Foundation, which is a foundation actually formed by the founder of UPS and the name of his mother, to come and help us with what is called a Juvenile Detention Alternative Initiative. And are there alternatives to incarcerations that better serve these children? The approach I think we had taken for too many years was to just warehouse people with no thought towards educating them, giving them counseling, the kind of things that are needed to prevent recidivism. So I'm very proud of my work in that area. One of the things that was used in connection with the detention alternative was, for the first time, an evidence-based risk assessment tool for the individual that plugged in a variety of factors and then told us what is the best suitable placement for this child and our community and the safety of it. Is it secure detention? Is it day reporting? Is it home detention? What are the services that this child needs? And that does two things. It prevents reoffending and it prevents somebody from being a crime victim. All right, so it's a win-win situation. Both the evidence-based risk assessment tool has now been taken statewide, both for juveniles and adults in our state, and the Juvenile Detention Alternative Initiative is now being taken statewide as well. So, to look back and know that I had something to do with reaching down and rescuing a child from the clutches of child abuse, or sticking my hand down in the abyss of juvenile delinquency and chaos that it is, and to know that I made a difference with my life in that regard, yeah, I guess it does feel pretty good. Improvements. As the lawyers, I'm sure, are aware, and some of you may or may not know, that 99% of cases in the state of Indiana begin and end in the trial court level at the courthouse. That's the justice that most all of us see in our lives. Our trial judges handle very, very complex and complicated matters, especially in the civil arena. What you probably don't know is most of them do not have the assistance of legal research, or what we call a law court, to help them independently research and make rulings in those cases. It's not that our trial judges are incapable of researching and making the decisions. They just don't have the time necessary. When I was a civil judge in Marion County, I took in about 2,000 new cases a year. And even with my best efforts at docket management, the low end of that was 1,600 to 1,800 cases at a given time. It's humanly not possible to read the complex briefs and give them the attention that they're actually due. It's not a wanting not to do it. It's not an incapability of trial court judges. They need the help. In Kentucky, they found a way to provide that help to trial court judges because presently, no county for the most part has funding to do that, all right? So we don't have it. Marion County doesn't. We do have, fortunately, the work of the Judicial Center. They have a research pod of staff attorneys that you can call into on a matter, but that does not replace the necessity of a day-to-day law. We also have the Robert H. McKinney School of Law, Notre Dame Law School, that fortunately provides legal interns, law students to assist in research. But at best, that help is one day a week. And really more of that experience is training, teaching, and mentoring the law student providing legal consultation to the judge. So back to Kentucky. One of the things that I'm assisting the Supreme Court with right now is looking at how can we create trial records more cheaply, more efficiently, more quickly for lawyers and the parties involved. And by doing that, in the state of Kentucky, they actually were able to fund law clerks for their trial judges. The next idea is really a continuation of something I mentioned in my first interview, and that's the full implementation of the Odyssey case management system throughout the state of Indiana. And I'm going to add to that e-filing. About a third of our county silos, as Chief Justice Shepard, was a great visual, by the way, stated in his State of the Judiciary address, the county courts are like silos of individual justice, and we need to connect them together. So the attorney in Kosciuszko County can find out from the case in Boone County, or Marion County to Boone County, or Mr. McDonald's from Bevo County, and determine what's going on with that case, what's been filed in that case. We're only able to do that because of funding in a third of the trial courts in our state right now. We need to do it in all 92 counties of this state. So when we talk in the state of computer information, I think it would astound most people to know when we can obtain information over the internet, just about anything, that we can't find out information about our cases over the computer. And fortunately, our Supreme Court has recognized this and worked very hard to do this. In addition to that, you can see what was filed, but wouldn't it be nice to see the pleading that was filed, or the document that was filed, just as if you went down to the courthouse? If we had e-filing, that is what actually, for lack of a better expression, scans the item or puts it in the system so you can pull up the actual document itself. These are things I think our Supreme Court continues to work forward in doing and would be happy to assist them with. When you want to do something like that and it costs money, you have to have a funding mechanism. And I have that experience in trying to accomplish those things in my career as a presiding judge and on the Court of Appeals. So you have to sit down with the stakeholders, the people that participate in the system of justice, and first educate them as to why this is necessary. You have to educate the public that, did you know this doesn't exist? Why? So get the public support for it. Then identify, how you're going to pay for it. And most of the time, in these times, it's by establishing efficiencies like consolidating the administrative divisions of the juvenile court and the Marion County Superior Court, like consolidating probation departments, which, under the strategic plan of the Judicial Conference, is now being done around the state. And the things that the Judicial Conference is continuing to do under the strategic plan, that is identifying overlap and efficiencies within the new 26 judicial districts around the state, so we can bring to the table a way to do things. Judges cannot sit and dictate to other branches of government that this is an idea that you need to pay for. You need to help and be, in that way, a partner in government in considering and finding ways to fund these things. These are ideas that I think would bear good discussion and would be good for our state.
Let me ask you about the juvenile justice question. What's your evaluation of where the society is headed there? That is to say, all the efforts that you described, are they moving the meter up or down? What do you judge whether the state of care for children, the state of families and the like is favorably affected by this?
I think when you're providing education, when it's for an incarcerated juvenile, or you're providing better education for a child that is another, some other form of pretrial release, that's something that's moving the spectrum up. It's like, I don't know if you remember in the Christmas Carol at the end of the Ghost of Christmas Present, he opened up his robe and he said, "This is ignorance of want, and these are the things that most fear." And those are the things that we should most fear in our society. So to educate, to avoid ignorance and the want that comes with ignorance and lack of patience. But medical care was something that was lacking in the facility. These are all good, admirable things. To teach a child that there is something better than committing your next crime, or how easy it is to victimize this person versus that person, I think that moves everything in in the right direction. That's why I'm pleased to see the discussion of sentencing reform. I've spent a lot of years being a federal and a state court prosecutor. Spent several years as a defense attorney, all right? I know that many of the things that we've done to date, while we're doing them for what we think are the right reasons in the 90s or the 80s, I think we're learning that some of them are not so successful. So if we're going to try and incarcerate less people, then we have to have meaningful reentry, whether it be out of the juvenile system or the adult court system. I think that moves the spectrum forward.
Great.
Yeah, I've heard this before. You mentioned evidence-based risk assessment. Can you just give me an example? I've heard of that. I'm not sure what it is.
It would show that a person that maybe had this criminal history background, had these connections for education, had these connections in home life and this and that we did that for this person here and it worked out well, or we did that for this person here and it didn't work out so well. Human beings, I think most of us learn over life are pretty predictable under certain circumstances. All right, those that have opportunities in education, we make the most of it. So you look at the factors that are individual to that person. There is another person in the world that has similar individual factors, and that predicts this. And that's why there is evidence now to base the release decision. So we're not just doing it because it sounds good or it looks about right, which quite frankly is what we've done for a lot of years without this.
Would you describe the most challenging ethical dilemma that you had to encounter? How did you handle it?
When I was assistant to the United States Attorney, I was heading an investigation of a large-scale cocaine money laundering and firearms ring from the Crick Street gang. They were infiltrating Marion County, surrounding counties. One of the pieces of evidence that we were putting together in that investigation was the search warrant of a motel room on the northwest side. And the lead investigator, a man named Pat Donovan, who was working with me on the case, brought to my attention that one of the officers that had served the search warrant had made a comment on the way inside that we're going to find dope in this place. And he did something to gesture where it drew in question whether they were going to find it because they were going to do a good job or somebody was going to plant dope, that was necessary. Under Brady v. Maryland, if there is something that causes to show exculpatory evidence, that is something that might show somebody to disbelieve that witness or is favorable to the accused, you have an obligation to produce that. As it turned out, well, after the investigation, no note was planted, but we disclosed that. And I remember what Pat told me: get them right or get them another day. And I heard that phrase. I don't know how many lawyers, prosecutors, and I tell prosecutors, you look yourself in the mirror every day and you say, I'm a prosecutor, I'm not a policeman. You know your function is different. All right? So that was a difficult ethical situation. To be honest with you, the action that I took was pretty simple. It was a simple decision.
What value do you see in having gender diversity on the court?
Well, I think diversity is certainly a factor to be considered, but diversity takes a lot of different forms. For instance, I have a broad and diverse background in the law. I know what it feels like to sit next to somebody in a jury trial that's been accused of a crime that I think didn't do it, that's looking at probably the rest of his life in jail, depending on my performance. I bring that diversity. I've sat with a crime victim and his wife during a trial of an individual that gunned down their 16-year-old daughter the day after her 16th birthday. I know what that feels like too. And I know what it's like to be a judge and that there's a time to show compassion. And there's a time when, quite frankly, you just got to do what you got to do. As a civil attorney, I know what it's like to service clients. I know what it's like to respond to discovery, to receive discovery, to represent that person's interests in court, both on the plaintiff and the defense side. And I've been a trial judge in many of those cases. And I've also been an appellate judge in all those kinds of cases, which is a different ball of wax. And that's the diversity that I like. Diversity is important, but there are many types of diversity.
But I mean this question seriously.
Yeah. Yes, sir.
How do we teach parenting?
We try and do that, all right? And I would just go back to, we do the best we can with this generation, and let's see if we can do better with the next, all right? We, in a CHINS or TPR case, child neglect case, there is an enormous amount of services that are provided to parents with a goal towards reunification of the party. Efforts are being made. But, you know, my wife is a kindergarten teacher here in Indianapolis. And there are parents that are involved in their children's lives, and there are parents that are not. How do you teach that? Well, you just can't roll over and say there's nothing you can do about it. So you try and reach down one family at a time and teach them. And because it didn't work for 5 families, you just not do it for the next 5. It's an enormous task, but anything worthwhile is usually enormous looking, but you have to wade into it and just try and do the best you can, one family at a time. Here again, see what's worked in the past, see what might work better in the future. I hope that helps. I don't know.
Is it the role of the judiciary to do that?
Well, like I said before, the law is not just about the written word, it's about people. And I think the rehabilitation of people in our criminal justice system, the obligation to see that there is open access and equal opportunity and privileges under the law is a constitutional privilege guaranteed to our citizens, and the person and the people that are supposed to make sure that happens are the women and men in the court system in the state of Indiana. And there's a fine line between dictating your personal views on things to a family and this and that, but just things that are good for society. And it's good for that family, and it's good for society as a whole. You can't turn your back on it. And you can't, as a judge, in my opinion, say that's this branch is a government problem. It's not. We're the place people look in the end. And we can't look anyplace else for justice, for help. We're the people they look to.
And what's the solution to funding?
Here again, establishing efficiencies in the court system, establishing efficiencies in how we provide services. For instance, before Judge Moore's got a handle on things in Marion County, when there'd be an action out there in a CHINS case, and there'd be 5 different putative fathers that were all getting services to be a better father, and they hadn't even determined who the one father was. All right. Now they take a cheek swab up front, establish paternity, so we're not spending money providing services to 4 people that are not the father of this child, and focus those efforts, those funds, those limited resources on this one individual. And by doing that, you free up resources. It's not on the back of the taxpayers. Right? We have a role in the judicial system to help find those solutions, as I've said before. I've always said that. We've done that in the context of juvenile justice in Marion County, done it in the context of solving the jail overcrowding problem in Marion County, and it's very on the top of my mind as I look at statewide problems and how I might contribute to the solutions of those services.
And ask if there's a professional experience, like given a chance to do it over again, would you do differently?
Yes, there would be a case, all right, that you may or may not heard of, all right. There was actually a ruling of a master commissioner in a court, and I had an opportunity to correct that ruling involved freedom of choice and religion. I missed the opportunity to do that. The Court of Appeals rightly reversed that ruling. At the time, I stated publicly that I agreed with that ruling, and I apologized publicly to the party involved for needlessly complicating his life. So what I'd like to say, and I'm glad you asked the question because it gives me an opportunity to say I believe in the guarantee of freedom of religion, not just my branch, but all religions, including Wiccan. All right, it's not for me to say. So that's the one I had like a do-over on. So.
Judge, what would you say? How would you characterize the word judicial philosophy?
It starts with, as guaranteed by Articles 12 and 23 of the Indiana Constitution, open access to the courts and equal privileges under the law to our citizens. Moving beyond that, as my role as an appellate judge, number 1 is I never reweigh the facts as they were found by a jury or by a judge. It's not my place. I wasn't there. I didn't get to see person, I didn't hear all the evidence. So that is one discipline that is paramount to me. Moving beyond that, in matters of constitutional or statutory construction, if the language of the Constitution or the statute is unambiguous, then you give it its plain and clear meaning. If it is ambiguous, then you try to determine what was the intent of the framers of the Constitution. What was the intent of the Indiana legislature? To do that, you would look at existing precedent and, as I stated before, use your common sense. As to the common law, you would look to existing precedent in our precedent, or I would look to existing precedent in our state, existing precedent from other states, and is the common law still workable for today's society in this vein and that sort of thing, all right? And so here again, common sense comes into play, and the patience to listen and consider other views before reaching that decision. And finally, as to the creation and promulgation of court rules, you would look at constitutional implications as they relate to things like due process and notice, and you would try and be practical. You know, a judicial decision involves three things. It involves informing, it involves directing and giving clear direction, and it involves inspiring, hopefully, by its result. And part of that is the decision maker, and it takes a long time to be able to do this. You have to be able to, again, know what the anticipated consequences of a court rule are for a decision, and you must also try and guess what are the unanticipated consequences of a court rule or a decision. And that's the beauty of having five wonderful people like our justices of our Supreme Court that do a good job of anticipating those things. That's the kind of thing that I would try and do if I was so fortunate. So I hope that answers yours.
So the interrogators have run their course. Is there something you like to add before we come to close?
Well, I look around this table, and for so many years, and over 2 centuries now, think about the important decisions that have been made, the far-reaching consequences of those decisions, and it's almost a little overwhelming to sit at the table and think that there are only 7 people in the state of Indiana that will now have a seat at that table. It's humbling. And I say this with the deepest sense of humility, that if I were so fortunate to one day join our justices at that table, I would always bring and never forget the broad base of diversity that I have in my life. And I would do my best to always assist by employing the administrative and management skills that I've learned. That I would continue to do my best to make thoughtful, deliberate, reasoned, and practical decisions. And would always try and be a decent human being. You know, I think that just brings collegiality and judicial temperament naturally. Yeah, it's such a difficult decision to make. And gosh, it's